Bonjour et bienvenue. Hello and welcome to Business and Human Rights Updates from Europe and Beyond. Le Centre de recherche de renseignement en droit de la personne de l'Université d'Ottawa et l'Association internationale du droit international du Canada sont très heureux de présenter ce premier webinaire Entreprises et droits de la personne, les avis consultatifs internationaux sur le change, sur les mises à date de l'Europe et la future. Dans notre série de webinaires sur les entreprises et les droits de la personne. My name is Una Fitzgerald, and I'm president of the International Law Association of Canada and an HREC Senior Fellow. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let us begin by acknowledging the traditional territories of Indigenous peoples. We are meeting virtually across Canada and beyond, so I would like to acknowledge that the Indigenous peoples, that is the First Nations, Inuit, and Métis, are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. Nous sommes reconnaissants de vivre, d'apprendre de cette terre et d'en profiter, et nous nous engageons à la décolonisation dans nos vies personnelles, nos entreprises, nos organisations, nos écoles et nos communautés. The International Law Association of Canada, or ILA Canada, is the Canadian branch of the International Law Association based in London, England, and founded in Brussels, Belgium in 1873. With over 5,000 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. This is particularly meaningful collaboration between ILA Canada and HREC because in 2024, the ILA initiated a committee to study the topic of business and human rights, and we're fortunate to have the co-chair of that committee, Marcus Grajewski, on this panel, as well as Damilola Olawuyi, who's an expert in this field and a member of ILA Canada. It's now my great pleasure to introduce Professor Penelope Simons, Director of the Human Rights Research and Education Center. Her research is focused on the human rights implications of domestic and international business activity, and particularly on natural resource extraction and how best to regulate such activity to protect human rights and prevent and mitigate other harm. She also considers the intersections between transnational corporate activity, human rights, and international economic law. Her current work is on gender and resource extraction. Penelope will introduce HREC and our three expert panelists and moderate this panel. Thank you, Penelope.
Thank you so much, Una, et bonjour à toutes et à tous, et merci de l'intérêt que vous portez à cet webinaire, le deuxième dans notre série webinaire sur les entreprises et les droits de la personne. Et nous sommes très heureux de nous associer à la section canadienne de l'Association de droit international. Welcome and thank you for your interest in this webinar. This is the second in our Business and Human Rights series, and we're very excited to be partnering once again with the International Law Association. In this second webinar, we're going to be discussing the rollback of the EU Corporate Sustainability Due Diligence Directive and its implication for laws in Europe for victims of corporate-related human rights violations and for the negotiations at the UN of the legally binding instrument on business and human rights, as well as other issues. The amended Corporate Sustainability Due Diligence Directive was adopted and approved by the EU Council on the 24th of February 2026 after the changes were agreed, and the EU Parliament adopted the text in December 2025. And it entered into force, at least that's my understanding, last month. So let me introduce our three speakers, who are three giants in the field of business and human rights. Nadia Bernants, who will be speaking first, is Professor of Law and Corporate Justice at Wageningen University in the Netherlands, where she's also the director of the Jean Monnet Center of Excellence on Corporate Sustainability and Human Rights Law. She's also the co-editor-in-chief of the Business and Human Rights Journal and the co-editor of the Ocean Yearbook, the author of Business and Human Rights History, Law, and Policy: Bridging the Accountability Gap. as well as a founder of a business and human rights blog called Rights as Usual. And her current research focuses on ocean law, human rights-based approaches to addressing the plastics value chain and climate change responsibilities. Our second speaker, Marcus Krajewski, holds the chair in public law and public international law at the University of Erlangen-Nuremberg. He is the Secretary General of the German branch of the International Law Association and co-chairs of the ILA's Committee on Business and Human Rights. His research interests include business and human rights, including human rights due diligence and international economic law. Our third speaker, Damilola Olawi, is professor and UNESCO chairholder on environmental law and sustainable development at Hamad bin Khalifa University in Qatar. He's currently the chair of the UN Working Group on Business and Human Rights. He's the author of the book Environmental Law in Arab States that earned recognition from the American Society of International Law in 2023. In addition to being a professor, he's an international lawyer and a policy advisor. In all three capacities, he focuses on business and human rights, energy, natural resources, and environmental law. Okay, let's turn to our speakers now. Nadia, please go ahead and share your screen. And we're hoping that you're going to be able to explain the key elements of the EU directive that was adopted in 2024, and then the changes that were made by this recently adopted omnibus bill, and what has been lost from the corporate accountability perspective.
Thank you. Thank you, Penelope, for your kind introduction. Can you hear me and can you see the slides?
Yes, it's a go.
Thank you. Okay, so I will be talking about the revised Corporate Sustainability Due Diligence Directive. As Penelope just explained, we have a new text, and I was asked to talk about the impact on corporate accountability of this new text. So just to remind ourselves, and for those who are not familiar, this is the very simplified timeline. In 2024, we had the adoption, after many years of discussion, of the Corporate Sustainability Due Diligence Directive. That same year in September, we saw the publication of the report on the future of European competitiveness, also called the Draghi report, from the person who led the research for the report. And this is an important development because following the publication of the report, which was critical of the corporate sustainability framework that had just been adopted, the Commission seemingly changed its mind and decided that this piece of legislation, as well as others, needed urgently to be amended. We can discuss whether this was the case, but in any event, this is what happened. And so in February 2025, the Commission made a proposal to amend the Corporate Sustainability Due Diligence Directive, the CSDDD, and also to stop the clock on its transposition, because this is European legislation that is not directly applicable to member states. This is legislation that needs to be transposed. And then finally, after a year of various discussions, as Penelope said, the revised CSDDD was adopted in February. So I want to start, and I think this is going to be basically the main message of this presentation, that the core idea of the CSDDD remains unchanged. And that means that this is a text under which companies, and we'll talk about which ones in a second, but companies must conduct risk-based human rights and environmental due diligence in line with well-known principles, the UN guiding principles on business and human rights, and the OECD guidelines on responsible business conduct. This doesn't change, which means that all the elements with which many of us may be familiar that come from the UNGPs and also from the OECD guidelines, this sort of circle of the due diligence process, identification, assessment, prevention, remediation, things like stakeholder engagement, having complaints procedures, monitoring effectiveness, and publicly communicating about it, this remains, right? So I think this is really important to realize that, because we read a lot of frustration around those changes, and I think rightfully so, and we can talk about this in a minute, but also at the end of the day, we still have that, we still have those principles, and those remain unchanged. Now, whether or not this is useful to properly address human rights issues and achieve justice is a separate discussion, but what we have is very similar to what we had. So that's the sort of broad idea. Now, there are, of course, changes between the 2024 version and the 2026 version, and I will now dive into those changes. Perhaps the most radical change is the personal scope of the directive, which companies we now see, as you can see in this table, that we have fewer in-scope companies, meaning companies to which the directive directly applies. There's a lot of figures circulating on the internet about how many companies are actually in scope. I've settled with about 4,000 EU-based companies, but I know there are different numbers circulating. I think at the end of the day, the core idea there is that it is very few companies, because we are talking about very large companies, 5,000 employees, over 1.5 billion worldwide turnover. There is room to potentially expand the scope that is into the revised version of the CSDDD, but at the moment, this is what we have. So a personal scope, which is much limited, and that's a very important change between the 2024 and 2026 versions. Going into the core of what companies need to do, some changes when at the identifying impacts stage, 2024 version, companies had to map their supply chain, identify high-risk areas, and then conduct detailed evaluations within those identified high-risk areas. The language in the 2026 version is slightly different. We don't talk about mapping, but a scoping exercise based on reasonably available information. And also, perhaps interesting from a practical perspective, that companies are not allowed to request information from business partners with fewer than 5,000 employees unless that information cannot be obtained by other means. All of that is supposed to make life easier for companies. I think we could discuss, perhaps in the Q&A, whether that actually will be the case. It's meant, I suppose, to make companies not bother smaller businesses with questions that could burden them. But at the end of the day, personally, and we could discuss that, I don't really see how that's feasible. If you need information, you ask information. If you need to find out how many employees the company have, I don't see how that simplifies the process, personally. But there are these changes in the language that are meant to make the process a little less burdensome and stringent, basically. Then we have addressing impacts, and there is an important change of language, I think. 2024 text was talked about what to do if mitigating potential human rights impact is not possible. There was text around, there was a provision that explained that companies had to suspend or as a last resort terminate the business relationship. The 2026 version puts stronger emphasis on suspending the business relationship as opposed to terminating it. So there's more encouragement from companies to just suspend rather than do the more say, nuclear option and terminate the business relationship. And there's also a provision around that explains that if a company continues to engage with a partner while they are working at the mitigation, then that shall not expose this company to penalties or liability. So a sort of safe harbor clause. It's not a revolutionary change, but it is a little change in again that is supposed to make life easier for companies. A big change to me is the periodic assessment, which in the 2024 version was supposed to be at least every 12 months. In the 2026 version, talks about every 5 years. Now, that I think is a big problem, and I think it defeats the purpose of the continuous due diligence cycle, which is supposed to be something that is done all the time. You start, you mitigate the impact, you address, you constantly learn. It's supposed to be a constant circle. Assessing that every 5 years, I don't really see how that's compatible with international standards like the UNGPs. So for me, some changes are cosmetic. To me, that's quite a lot. I actually don't see how that's really feasible, to be honest. But that's an important change. Another important change that's been much discussed, I would say, since already the discussions, the debates about the new directive, are 2 points: the stakeholder engagement point and climate obligations. The 2024 version had a very famously wide definition of who is a company stakeholder, and also had an obligation of meaningful engagement and consultation in all the steps of the due diligence process. The 2026 version talks about companies that must consult relevant stakeholders, which is supposed to be a shorter list, but who is a relevant stakeholder is not defined. And the relevance is basically to be determined by the company on a case-by-case basis. So it's narrower. Who is a stakeholder is at the company's appreciation, essentially, at least in the text. And then the 2024 version of the directive had this obligation for companies to adopt and put into effect annual transition plans for climate change mitigation. The 2026 version has removed this requirement entirely. So we don't have those plans anymore in the text. This is going to be interesting to see how it works in practice, because of course climate risks still fall under due diligence, but now we have a lack of guidance, which could lead to uncertainty for companies. So we'll have to see how this is put in action. Just looking at the time, yes, I have 1 minute. So another change regarding enforcement and civil liability. So the 2024 version had, first of all, set up an obligation for states to have their own public enforcement mechanism. This remains completely unchanged. It hasn't been touched in the 2026 version. So we will still have states creating their agencies if they don't have one, that will have to monitor how companies are doing with putting implementing the obligations under the directive. So that doesn't change. The big change is around civil liability. We had in the 2024 version some rules around harmonized conditions of civil liability for companies in case of damage, and also a very important provision that required states to allow trade unions and NGOs to bring actions to enforce the rights of alleged injured parties, alleged victims of corporate human rights abuse. That was removed. So now member states have to design their own liability regimes, and there's no EU-wide harmonization, which means, and I haven't looked into this in detail, but I suppose in some countries it's more difficult than in others for NGOs to bring claims on behalf of victims. So that could be an issue moving forward. There's also in the 2026 version, and I don't think this was in the 2024 one, this maximum fine of 3% of net turnover, which I believe we didn't have in the previous version. And finally, and I know Marcus is going to talk about this, but I wanted to introduce this idea of maximum harmonization, which is a term in EU law that signifies basically that the directive sets a floor, but also a ceiling, which means member states are prohibited from introducing more stringent provisions than those that are laid down in several articles. We already had that in the 2024 version, but the list of provisions about which states cannot go further is much longer in the 2026 than in the 2024 version, which means that states have much less leeway, and I suppose civil society organizations who will campaign now and work with states on transposition, they will be able to require less of states because of that provision. So what does that mean for corporate accountability? I tried to put the good parts in green and the more problematic parts in orange. Like I said, the core idea remains. We still have the elements of the due diligence process. We still have, of course, the UNGPs and the OECD guidelines. Public enforcement remains. I think this is an important provision. All in all, I find it hard to foresee the impact of some of the changes in practice. So, for example, this idea that there's a narrower list of who is a stakeholder, with companies that are left to determine relevance for themselves, I don't really know what impact that will have in practice. Isn't that always the case, that companies look at relevant stakeholders and whoever is relevant is a stakeholder? I mean, it's this kind of seemingly simplifying language that in practice I'm struggling to see how it will work. On the more clearly more negative side, the narrow scope, of course, is a problem. And that means fewer companies will be concerned with the directive. There is a more superficial understanding of impact. This suspending versus terminating business relationships, I think, gives a lot of leeway, possibly too much to companies. This less strong monitoring, 5 years versus 12 months, for me, that really defeats the whole point of the due diligence cycle. We talked about stakeholders, and no climate plans and no harmonized civil liability, for me, are also important issues. So I will leave you with that, and happy to take questions also at the end. But I think we're going every speaker at one after the other, right?
Yes, exactly. Yes. And then we'll come back to each of you for a shorter question. Exactly. Thank you so much, Nadia, for setting that out so clearly. That was really great to really understand these, how this directive has been walked back and some of the problems with that. Let's go now to you, Marcus, if you want to start sharing your screen. Would you please comment on the implications of this rollback then for state human rights due diligence laws?
Yes, I'm happy to do so. I hope you can all hear me and you can see also the presentation. So I was asked to go a bit more detail into some of the questions that were raised by the recent changes of the so-called CSDDD, in particular with regards to the diligence laws of EU member states, so states that already have those laws. And of course, as I suspect many in the room know, this concerns mostly Germany and France. So maybe before I go into the details, let me just very briefly sort of just underline what Nadia said. So this is a piece of EU legislation which basically is not directly applicable. So all the details that we're discussing when we look at the text right now are actually almost theoretical discussions, at least from the perspective of companies, because companies will tell you, well, I'm a company registered in Italy, and therefore the directive doesn't apply to me directly, rather whatever Italy makes out of the directive. So we will see some of the details that Nadia presented. We will see how they transpose actually into domestic law. And then the question comes whether the member state has successfully and efficiently transposed the law. So if a member state hasn't, then of course other states or the Commission can go to the European Court of the European Court of Justice. So I'm just saying this so that participants understand. Of course, it's important to know what is in the directive, but when it comes to what companies have to do, it will be the domestic law. And this is also why it's a bit of a strange structure there. So member states are obliged to transpose the directive into domestic law until 26th of July 28. By that date, they have to report to the Commission where is, so to speak, where is the directive in your domestic law. They don't have to actually start applying the law, so they still have until July 29 for the application for that. And for the reporting obligation, it's even until July 2030. Now, this is, of course, important because that's what companies are looking at, and that's what companies are lobbying for. Of course, companies or business associations are lobbying for late transposition. So when we now look at the EU member states, of course, a member state that doesn't have a due diligence law, they will have to develop their own law or incorporate the obligations of the directive into an existing law. They could also say, well, take a chapter of the company law or the code of corporations or any other law that they have. They have to transpose it. It's important. It has to be a legislative piece of law. So you can't just say, well, we'll do this with administrative guidelines or something else. Now, EU member states that have a law may have to change the law, but more importantly, may also now have an opportunity to change their law. So I think it's important to realize that this, of course, politically opens a debate now, specifically in France and in Germany, when there are discussions about changing the law in light of the directive. The question is also, well, can we also get rid of something that we already have? So, and of course, in France, we look at the Loi de Vigilance, and in Germany, we look at the Lieferketten-Sorgfaltspflichtengesetz. And those of you who know a little bit about German know that we love to squeeze everything into one word, and this is why we come up with these wonderful long words. It is, of course, the supply chain due diligence law. And more importantly, not more important, but importantly, it is going to be revised in 2026, independently of the CSDDD. So if you are a German company or work with German companies, you may have heard that they are not only complaining about the law itself, maybe, but also about the fact that the law was adopted in 21, became effective in 23, then the directive came about, then the omnibus came, then the German law was changed independently of the directive. It has to be changed again. So basically, it seems that companies have to look at different legislative requirements almost every year. Before I go into the details, let me talk about, Let me talk about two EU law principles, which Nadia already mentioned. So we have in the directive, we have two articles which are important. The first is Article 1, Paragraph 2, which is the so-called non-regression clause. This is actually something that comes from EU law already for quite some time. And the idea here is that once you have a directive that you should transpose, you shouldn't use that as an excuse to basically reduce the level of protection that you already have. That, for example, in environmental law, a country may have already quite strict environmental laws, then there is an EU harmonization, which may be at a lower level. And then the argument is, well, if you already have reached a higher level, you should at least not use EU law as an excuse to lower that level. There's a big debate as to how far that actually goes, but Article 1, paragraph 2 is quite specific that the CSDDD, it should say on the slide, shall not constitute grounds for reducing the level of protection provided for by national law of member states. And that was already part of the original CSDDD. So many colleagues in Germany said, well, that's important because it means even if the directive gives us more leeway, in certain areas, we cannot actually go back. Now, the omnibus now changed that and added a second sentence, and that says that this does not prevent member states from, and here I quote, adjusting any national corporate sustainability due diligence law applicable at the time of the adoption, in particular their scope, with a view to aligning them with the directive. And this actually was specifically, I guess, included because of lobbying activities by business associations from Germany. So the question for German and French law will be, when will a change of an existing due diligence law be a prohibited regression of the level of protection? And when will it be a mere adjustment? And of course, you can imagine this is a lot of stuff for EU lawyers to discuss, and maybe there's also going to be even litigation in front of the European Court of Justice. The second aspect, and that's what Nadia specifically referred to, is harmonization, level of harmonization. Now, in more recent EU directives, we see this, that the directive itself basically points out or establishes which elements are subject to so-called full harmonization or maximum harmonization, and which elements are minimum harmonization. So you can basically think about it in the floor and the ceiling perspective. So if it's a full harmonization, member states may not go below, of course, but also not go beyond the provisions. Now, the EU law argument is, of course, to say, well, if we have harmonization, we'd rather want to have it a real harmonization. So we want to make sure that there are not different regulations all over Europe. That's the argument for full harmonization. But of course, in the context that we are discussing, it means that if you have a large number of articles that are subject to the full harmonization, it also means that member states cannot be more strict. You will note, for example, but that the full harmonization provision does not cover the scope. So member states could actually provide for a broader scope of the implementation legislation if they want to do so. I mean, of course, there will be, again, lobbying activities against that, but it's important that the scope is not subject of the full harmonization. Member states may also adopt more specific provisions concerning certain products and services to achieve a different level, but any deviation from the CSDDD by member states must be measured against the harmonization obligation. So we will not only look at whether the member states' laws have implemented the CSDDD, but also which elements we're looking at. Are we looking at the full harmonization, maximum harmonization, or are we looking at the minimum harmonization levels? Now let's go to France and Germany. Now, as a German lawyer and academic, it's of course always very, very risky to talk about French law, but I'll do it anyway. And I hope the French lawyers or the French-speaking lawyers in the room will forgive me if I say something wrong about the French law. Now, the French law has the beauty, at least for a German lawyer, that it's relatively short. So one can already identify, I believe, some changes that are necessary. So I would argue that it's probably necessary that the French legislator defines and substantiates the due diligence obligations. I mean, the French law is relatively short on that. Of course, there is now jurisprudence coming out, but I would argue that from an EU law perspective, the lawmakers need to be more substantiated because the directive is quite substantial on what actually the different elements of the due diligence obligation mean. The French lawmaker probably also has to define and substantiate human rights and environmental risks. Currently, the French law is very broad. It speaks about human rights and fundamental rights and health and environment issues. my feeling is that from an EU law perspective, the French lawmaker probably has to also make that more substantial. And of course, the French lawmaker has to enact an administrative enforcement, meaning designate a specific agency and then establish administrative proceedings. Now, with regards to possible changes, it's possible, and here I'm not an expert on French civil liability law, that some of the provisions that are, as Nadia rightly pointed out, are still in the directive on civil liability may require the French lawmaker to change some of the law, the civil law provisions as well. And it's possible that the French lawmaker thinks or may think about decreasing the coverage of the French law by adding the 1.5 billion euro threshold to the already existing threshold of 5,000 employees. So the French law has, at least for domestic companies, already this 5,000 employee thresholds, but it doesn't have the 1.5 billion euro annual turnover, which is sort of a cumulative requirement in the CSDDD. So this is something the French lawmaker could be thinking about. The German lawmaker also has some homework to do. Certainly, the German lawmaker has to increase the scope concerning environmental risks. The German law only is limited to only 3 very, very specific environmental risks. The directive is much broader. The German lawmaker probably also has to change the approach in the German law, which is right now still very much limited to the companies themselves and their direct suppliers. Possibly also more detailed regulation of the due diligence obligations, and there are a number of elements in civil liability. For example, and this is maybe something that has not been discussed so much, but the CSDDD says that the limitation period for claims based on national law has to be 5 years. Now in Germany, it's a general tort claim, which only has a limitation period of 3 years. So the German lawmaker certainly has to change either the supply chain due diligence law or the German civil code in saying that if you raise a claim based on the due diligence violation, then the statute of limitation is 5 years. Again, it's possible that the German lawmaker also thinks about reducing the coverage of companies, because right now it's 1,000 employees. And there's been some discussions as to whether the German lawmaker also has to increase the independence of the administrative agency. We already have in Germany an administrative enforcement, but some argue that because it's a unit within the scope of the Ministry of Economics, it's not entirely independent. I guess that's also something that still requires some research and discussion. Let me finish by very briefly reflecting again on this idea of reduction of the coverage. So of course, we could argue that the reduction of the coverage of the laws would be a prohibition of the level of protection, because, you know, if you have right now in Germany, there's about almost 5,000 companies that are covered by the law as it stands right now. If that's being reduced, of course, this is a reduction of the level of protection. But then again, the second sentence of Article 1.2 allows the German lawmaker to do that. This is the moment when general international human rights law kicks in, and I'm not sure whether Damilola wants to say something about this, but Article 2, paragraph 1 of the International Covenant on Economic, Social, Cultural Rights has this idea of progressive realization. And one could argue that the obligation of progressive realization includes a general prohibition of regression. And therefore, even though the German lawmaker could be allowed to reduce the level of protection on the basis of EU law, the German lawmaker might be prohibited from doing so based on international human rights. Now, unfortunately, EU law is, of course, much easier to be enforced in front of the European Court of Justice. When it comes to international human rights law, Germany would probably only have to answer to the Committee on Economic, Social, Cultural Rights. But from a substantive point of view, I think that argument can be made. And I leave it with that and also look forward to questions and comments. Thank you very much.
Wonderful. Thank you so much, Marcus. That was very helpful, and really brought out the points that Nadia had made about what we've kind of lost from 2024, moving through to the domestic area. So thank you so much for that. Let's move over to Demilola. So feel free to share your slides. Could you please provide us with a brief update on the Business and Human Rights Treaty process, including some key highlights from the current zero draft that relate to human rights due diligence, and then talk about what the implications are for treaty negotiations, the fact that there has been this rollback of the EU directive.
Thank you very much. And I must start by congratulating the International Law Association Canada, especially UNA, for this great initiative and opportunity. I must also thank the Human Rights Research and Education Center under the leadership of Penelope for this great initiative and for all the work that you've been doing at the center to advance business and human rights knowledge. Of course, I bring compliments from the UN Working Group on Business and Human Rights. And it would have been easy for me not to talk about the working group. But anytime I talk about the legally binding instrument, or anytime I'm in a conference at all, I get attacked by people saying, you guys have been negotiating this thing for 14 years and you've not done anything. And I'm like, for many years. And I'm like, well, first point to clarify, our working group is different from the intergovernmental working group that has been trying to negotiate this since 2014. So let me start with that disclaimer and maybe just clarify a little bit what our working group actually does and what it does not do. And then I will then move on to talk about progress or challenges since 2014, and then some of my reflections on how the rollback or dilution of the EU CSDDD, how it even worsens the progress made and how we can address that going forward. I think Nadia and Marcus already made my work easy because they've already discussed the EU CSDDD. The Working Group on Business and Human Rights was established in 2011 as part of the UN's effort to implement the very wonderful report that Professor John Ruggie had drafted and developed, which later, for the most part, became the UNGPs, the UN Guiding Principle on Business and Human Rights. And of course, I think it was in realization of the fact that disseminating and implementing the UNGPs will require a working group that will take the message across the world. That was when our working group was established as part of the adoption of the UNGPs. And this is the working group. That's me when I became a member in 2021. So the UN working group has the mandate to advance, promote, disseminate the guiding principles. And we do that in partnership with stakeholders through our many activities. The working group is made up of 5 experts from different world regions. I am the member from African states on the working group. And our activities, some of you already follow and engage actively in our activity, especially the center. 2 country visits, and I believe we've visited Canada in the past on our official country visit. We draft and present 2 reports every year, one to the Human Rights Council, one to the UN General Assembly. And we have a communications procedure through which anyone in the world can send complaints, consent to us, which we do investigate. And of course, our flagship event is the annual Forum on Business and Human Rights, which happens in November every year in Geneva. In addition to all of this, we take part in the negotiation process of the legally binding instrument. We are often invited by the Intergovernmental Working Group to give our thoughts and opinion about the process. So even though we don't lead it, we are very much part of the process. Now, this is just a breakdown. More than 18 country visits now. We've treated more than 1,100 communications from different parts of the world. We've presented more than 30 reports to the UN Human Rights Council and the General Assembly. And we are preparing for the 15th annual forum this year, which will be the celebration of 15 years since the UNGP. So if you are not already planning to be with us in Geneva, I hope you can be there for this important forum this year. So, like I mentioned, in order to advance and move beyond some of the progress that we've made in disseminating the UNGPs, of course, the effort was made since 2014 when the Human Rights Council adopted Resolution 269, which established the Intergovernmental Working Group. It's called intergovernmental in UN lingo because it's actually led by states. And so you have the permanent mission of Ecuador serving as chair of that Intergovernmental Working Group. And I want to say that since 2014, when the working group has been meeting, there's been challenges with making progress. And I always like to say, look at the vote that led to the creation of this working group, and that already tells you that out of more than 100 UN member states, out of only 20 voted in support of even the establishment of this working group to negotiate a legally binding instrument. 14 said no, 13 abstained. So I am personally not shocked that there's been little, or I would say there's been slow progress, given the almost very thin political will that is backing the process itself. Now, from that, I would say, faulty start, then momentum began to grow. States coming up with ideas. So different sessions, 11 so far from 2015 to 2025. Now we're preparing for the 12th session in October. Currently, there's been a fourth revised draft. There's been a return back to the third draft. And some of the key issues that have led to this back and forth will be things like, some states have argued that the scope of the LBI, of the legally binding instrument, should apply to all transnational corporations. Some argue that, well, it should be to all businesses. It should not only be transnational corporations alone. There's been argument or debate over should it be business responsibility or should it be business obligation. Of course, one has a much more stronger connotation. Of course, obligation is stronger in law compared to responsibility. So while some states would want obligation, businesses, of course, would prefer responsibility. The language of abuse is something that businesses have tried to object to, and some states have bought into the argument that, well, maybe it should be violation, it should not be abuse. Of course, the attempt to incorporate environmental rights, especially in the aftermath of the adoption of the UN General Assembly resolution on the right to a clean, healthy, and sustainable environment, has also been one of the bones of contention. Should there be a language of environmental rights in this, especially given that as good as the UN resolution on the right to environment is, it's not a binding instrument. It's a resolution, right? It's a soft law instrument. So there is concern that by the time you then include that language in a legally binding instrument, then you have just taken that recognition beyond what the UN General Assembly did. So you have just elevated it into a substantive right. So there is also question about smart mix of approaches. Should there be mandatory human right due diligence, or should it just be human right due diligence, not mandatory? Or should it just even be human rights impact assessment? There's been questions about, of course, while some states would like to see more protection for children, indigenous peoples, and other marginalized groups, more protections relating to gender. Some have argued that the focus should not be that expanded. right? And this is an example of what has been going on for years. The chair introduces a text, then there is an intercession period, and then different states come back with their own understanding of what should be included, what should be deleted. So you can see the proposal by Mexico, Panama, Brazil, Chile, Ecuador, Honduras, in the context of the definition of human rights abuse, things that should be deleted, and so on. And with all the definitions, you can see the contentions that have been going on. Because of time, I will not, unpack each of the debates. But like I've mentioned, the debate can be categorized into maybe just broadly 5 questions of scope of application. Should it be all businesses or transnational corporations? Should it be human rights abuse or violation? Should it be, international organizations? Or should this apply to state-owned enterprises, or should it just apply to private enterprises? Language of who is the victim, and the like. In terms of the prospect, I would say that one of the key things that we thought would move the process forward was the momentum created by the EU CSDDD, right? I have attended many of the negotiation sessions, and the CSDDD always came up as the bright light, as the hope that it is indeed possible for us to counter corporate interest, for us to have a common language, that could then, especially given EU's leadership in terms of being a very strong leader when it comes to environment, sustainability. So I would say that the rollback and dilution of the CSDDD has significantly reduced the ambition of the LBI process. It has also it has weakened the momentum for sure. It has given more corporate, it has given corporate interest the opportunity to see what is possible. And I recall even the process of the rollback itself, was a shock to many of us that were following the progress that had been initially made. Another key challenge that I see with the impact of the CSDDD is that it introduces fragmentation. We were looking at the CSDDD as a framework to achieve that international liability regime, right? But now, that the rollback simply introduces or takes us back to the era of fragmentation, which we thought we had overcome over time. And I want to say another issue that I feel that I strongly see with the rollback, especially some of the events that led to the rollback itself. It just shows that corporate leverage remains a big concern and a big hindrance to even the adoption of a legally binding instrument. And I see that if one did not know before, then the rollback emphasizes that. In fact, the rollback also led to concerns as to whether the mandate of the Intergovernmental Working Group would even be renewed, or whether everyone would just say, well, you know what, that's it. It seems an international framework may not be possible. So in light of this, and what's the way forward, really? And some of the recommendations that our working group made in this document, on UNGPs plus 10 still hold till today. I think the last session of the Intergovernmental Working Group session indeed suggests that the treaty process may be very close to its final stage, but may be impacted or slowed down by lack of political will. And so there is a need for an approach that now addresses some of the concerns that I've raised, especially balancing concerns over sovereignty and rights of states, to advance in a way that sustains their economic interest, balancing that with the imperative of protecting human rights. Political will will be needed on that. There is, like I said, there's fragmentation now. The language of the CSDDD, the diluted language, in fact, weakens some of the progress that we thought we've made as a working group with disseminating the UNGPs. There is now a need to pursue strategic alignment, because if the CSDDD remains poorly implemented or weak, then the future of a legally binding instrument will be that of a weak one, which may even then make the UNGPs look very beautiful and good, because even though they are soft law norms, they've worked in raising awareness. So I think that alignment would be very great, ensuring that the draft treaty, especially human rights due diligence provisions, complement and reinforce existing instruments, especially the UNGPs and the CSDDD. There is also, like I said, the need for stakeholders, CSOs, to continue to highlight how corporate influence impacts negotiation process. This is what we have seen with the legally binding instrument. It is what we have seen with the CSDDD. I think that political will question will remain crucial, will remain a barrier to progress, both with the legally binding instrument and with the effective implementation of the CSDDD, if the impact of corporate influence is not well understood. And I think scholars and academics, CSOs, can indeed play crucial roles in highlighting the need to reduce corporate influence. We see this in practice in Geneva every time. We see how even some states adopt corporate positions as their own official positions, which has made progress very, very difficult. And I have already talked about the need for multi-stakeholder partnership going forward, so that they can own the process, the process of the legally binding instrument, and see themselves as key actors that would also promote awareness, education on this. And I think the need for capacity development will also be crucial, and international cooperation. The draft provisions on international cooperation and mutual legal assistance, which will need to be strengthened to promote that multi-stakeholder opportunity for capacity development for cooperation as far as the business and human rights agenda is concerned. I'll leave it at that. Thank you very much.
Thank you so much, Damilola. That was a great overview of what's been going on, and then also a very depressing sort of accounting of some of the impacts of the rollback of the CSDDD on the treaty process. I wanted to ask now each of you, we have, if you could take maybe 2 minutes, if you're able to, just to reflect on the implications of this rollback for those seeking remedies for business and business-related human rights violations in this context. Do you want to go first, Nadia, or?
Sure, thanks. So just to go back to what I was saying earlier, I think all the other instruments that we've had for many years are still here. And Marcus also explained how the timeline, like until this kicks in, there's still years. Yeah, until I'm talking about the CSDDD, until it really makes a meaningful difference to what we currently have in European countries. So I don't know if I want to call it a rollback as such.
Okay.
Like, this is nothing changes, basically. And so the other thing is that, as you know, when we talk about victims and remedies, very few of those issues actually end up in court, let alone with a judgment. So for, let's say, the business and human rights framework, the business and human rights agenda, I would even say, just remains, and those tools, as weak as they are still in place. So I really don't want to sort of spread the message that this is terrible and it's, we've lost everything we had, because I will make this point that even the 2024 version was not a revolutionary text by any means, right? It was UNGP's plus, but in terms of the strength, and it's only Europe, right? You in Canada, you can also do your own thing. Other countries can do their own thing. So I don't think it's the catastrophe that some make it, basically. And I don't think it concretely changes that much for potential victims. Now, of course, there's a reduced scope. If the company is not in scope, it's not in scope. It cannot be sued under that particular piece of legislation. But I don't think this is really how most business and human rights issues are addressed or can be addressed concretely. So, yeah.
Thank you, Nadia. Yeah, just on Canada, I mean, I do think it will have a bit of an impact here because we've been such laggards. And had there been more companies covered, that might have then created some will among those companies that were covered to lobby for something to level the playing field for themselves. But yeah, I absolutely take your point on that. So thank you. Marcus.
Yes, thank you. Maybe just very quickly, and I agree with what Nadia said. So I think it depends really on what kind of a narrative we want to pursue. And of course, people pursue different narratives for different political or whatever reasons. But I often think these days, what if what we have now would have been what we got 2 years ago and nobody would have changed anything to begin with, right? I'm not sure whether we would then say, oh, this is the worst thing that could ever happen. We would say, oh, this is great. This is an EU directive and it goes beyond the scope of the German law. And of course, maybe it has the same in scope as the French law. But so maybe we were also, how should they say this? We were spoiled. We were spoiled by, to begin with, the proposal of the European Parliament. Then we were spoiled by even more radical amendments from certain fractions of the European Parliament. And we saw what could have been possible if we would have a different political environment, which we don't have. So to a certain extent, what we're seeing now is as far as we can get in the current political environment, but I still think it is a lot. So I don't want to tell this narrative of a rollback. And I mean, people who in Geneva use the fact that there's been an omnibus to argue that now everything is over are playing a certain agenda. And I think we should not play that agenda. Now, in terms of what is in for victims and for rights holders, I think it's going to be very interesting to see whether in the future, maybe already in the next couple of years, there will be lawsuits against the administrative agencies. And of course, that's not against the companies directly, but it will bring a lot of very interesting questions to the table, all relating to very traditional human rights law questions. I mean, what does the duty to protect actually mean? How far do states have to go when they are protecting human rights against negative impacts by third countries? So with regards to that, I'm actually, maybe this is also in my nature, but I think I'm more optimistic than pessimistic, and I think we definitely need to push for level playing field now more than ever. And of course, the forum to do that are the negotiations in Geneva.
Thank you, Marcus. And I'll take both of your points on that and stop calling it a rollback. So over to you, Damalula.
Well, definitely, I think Marcus, it's the point that on the fact that in Geneva, a lot of civil society actors will prefer to call it a rollback. And that's, but of course, rollback, retreating, dilution whatever language we think might be better, still emphasizes one thing, which is that the EU is perhaps a victim of its own ambition and success or leadership in the past on this issue, right? And so the CSDDD came forward with a very strong template, which a lot of civil society actors have been using for advocacy, even in other parts of the world, especially in Africa and the Middle East, where discussion on business and human rights is perhaps only just starting, right? So the CSDDD was seen as an example of what could be done at a regional level. So, but I agree as well with Nadia and Marcus that it does not necessarily mean that everything is done, or we have a document that is of no use. No, it's just that in the context of a legally binding instrument, when everyone was trying to achieve that momentum to show that we can actually have an instrument that holds corporations to account. We can have a very ambitious instrument. When you then see a powerful bloc like the EU bloc sort of scaling back its initial understanding, then it raises those sort of and I can say perhaps at times some states can even use that as an excuse to not do more. But otherwise, we should. I always emphasize that in the business and human rights agenda, any progress is good progress, because the truth is that we need to hold corporations to account. We need to ensure accountability for corporate manipulation of the economic and industrial processes. And the best way we can do that is to strengthen our legally binding instruments, and hopefully we will achieve that legally binding instrument at the international level soon.
Thank you very much, Damilola. Okay, we have about 20 minutes left, so there's a couple of questions in the Q&A, and I'm going to turn it over to, I'll read those out. So the first one is from Sylvia Jackie. And she says, "Dear all, thank you very much for very informative presentations. I wanted to ask your thoughts on the ombudswoman's or the ombudswoman's opinion regarding the legitimacy and legality of the omnibus process, as well as the Commission's response. In your view, does this risk opening the door to legal challenges to the 2026 amended text?" Does anybody want to jump in on that question?
I can say something. I'm looking at Marcus in case you know more. Thanks, Sylvia, for this question. So I haven't talked about this, and maybe the audience is not aware of this necessarily, but the Commission decided, of course, to change the text that was just adopted, and I haven't insisted on that perhaps enough. And that was very unexpected. I mean, I guess it always depends what information you have, right? But at least for me, it was unexpected. I think for a lot of us, it was a very sudden turn. And I've explained that I think we can trace this turn to the publication of the Draghi report, which basically opposes competitiveness and human rights. Not in those terms, but basically uses competitiveness as a reason to, and I quote, unburden companies. And we could discuss the economics of that and whether this is correct or whatever. The reality is that the Commission took that, dare I say, at face value, and did a change and decided, well, now we need to reform a number of texts, including the CSDDD. And not only did they do that very quickly after having adopted the text, but they also decided that this was now an urgent matter, and therefore used the urgency procedure not the normal legislative procedure that is normally used in EU lawmaking, which involves consultations and impact assessments, etc. They fast-tracked it. And essentially, some organizations have taken this matter to the EU ombudsperson mechanism, who has concluded that there was maladministration, that's the term that was used in how this process was conducted. So there's definitely some issues around that. I would add other issues, which is predictability, the rule of law, and also for companies' preparedness, right? Some companies had started to prepare, and now this is taken away. So long for harmonization and leveling the playing field, you know. Now, what I don't know is whether that can actually lead to a process whereby the directive could be called into question and taken back. I don't think so, but Sylvia, I don't know the answer to this question. I do know that Alberto Alemano at HEC Paris, that he's been really vocal about this on LinkedIn and has talked about this urgency procedure and has very much criticized it. And so maybe he's posted something to that that would say a little more about what the procedure is. But I actually don't know the answer. But I absolutely agree that this is very problematic from the perspective of predictability and the rule of law, that this change was so sudden. Small changes, as we saw, but nevertheless, going back to something that had just been adopted, seemingly for no, I think, for no clear, real reason other than this displeased a few business organizations. So.
Thank you. Marcus or Damalola, did you have any other? Go ahead, Marcus.
Yes, just very briefly. Also, I guess that would link it to the question that was just posed. I mean, I think it's all well and nice to blame Mr. Draghi and blame Mrs. von der Leyen, but I think we should also be fair in saying we need to blame the European electorate, because there has been an election to the European Parliament between the old CSDDD and the omnibus. And the European Parliament significantly shifted to the right. And so the old majority that existed has been gone. I mean, those of you who follow European politics know that we are increasingly seeing the Conservatives voting now with the far right to get their agenda through. So I think the constellation in Europe is different. I mean, it's the same Commission president, so it looks like they've just changed their minds, but they're basically following also something that at least one could argue that basically European voters voted for to a certain extent. I mean, I'm not saying that was actually on the table, but I just want to point out that there has been a significant change in the composition of the European Parliament. And the second point, I mean, yes, when it comes to sort of, I've also seen that people argue now that the omnibus is a violation of EU primary law. I mean, first of all, substantively, I'm not sure that argument goes very far. And secondly, I'm not sure whether any of the privileged claimants that could raise that claim, which are the member states, the Council, or the European Parliament, will actually bring that to the European Court of Justice. So I think this is, I hate to say it, but I think this is an academic debate.
Damalola, did you want to jump in, or should I move on to the next question?
Yeah, I was going to jump in on the next question, so maybe you can.
Oh yeah, great. Great. So this is a question from Eric Bayani, and I don't know which one you were going to jump in on. There's two here, but I guess it was the guiding principles, or was it the one on the German Supply Chain Act? I'll read whichever one.
Yes, the guiding principles one.
Oh, okay,
and
so
there is one on the rollback and political will as well from Karen.
Right. Yes. So, okay. So the next question then is from Eric Bayani. How can the UN guiding principles be effectively implemented in gray zones where the state has lost territorial control to non-state armed actors, like in Rubaya, North Kivu, in the eastern part of the DRC? So go ahead, Timolo.
Thank you very much. It's a very important question. And our working group has actually released a number of reports on business obligations when operating, business responsibility when operating in conflict-affected zones and heightened risk areas. And we do recommend that in such zones, conducting human rights due diligence alone will not be enough. And that's why we do recommend heightened human rights due diligence. And heightened human rights due diligence will include putting the conflict in perspective when developing both anticipatory actions and when responding to challenges. So we expect businesses to assume more responsibility in implementing the UNGPs in those conflict-affected zones, which you describe as gray zones. But there is also a requirement on responsible exit. When should a business consider it unethical and not right-based to remain to be operating in a conflict-affected zone? When should they leave? How should they leave as well in a manner that does not affect human rights? So I think the UNGPs emphasize the need for heightened action, that is, heightened responsibility by businesses when in conflict zones, so that they do not contribute to the conflict, or they do not worsen human rights impact in those zones.
Thank you. Thank you very much, Damilola. What I'm going to do is I'm going to jump over your second question at this point, Eric, and come back to it just so that everybody can at least get one question in. So the next one is from Kaima George Chuka. And it says that given that transnational corporate activities increasingly exceed territorial boundaries, how are the legally binding instrument discussions, rethinking jurisdiction and responsibility to address harms that fall outside the traditional state-based frameworks of international human rights law?
I can take that if no one else is interested in it.
Sure.
Yes. Well, it's a very brilliant question, and I think one of the key challenges we've seen with the LBI process itself is the whole concern about parent company subsidiary responsibility. Should the LBI apply to state-owned companies? Should it not? And I mentioned some of those. One thing we must keep in mind is that the whole discussion about business and human rights assumes that states are the primary duty bearers when it comes to addressing human rights impact. But then it goes beyond that to then place some responsibility on businesses themselves. So the business and human rights agenda already moves beyond the traditional state-based frameworks. It's an attempt. The UNGPs, the LBI, are both attempts to place direct responsibilities on businesses themselves, and that will include, responsibilities relating to the subsidiary, the parent responsibility when it comes to the activities of the subsidiaries and the likes. So I would say that the LBI process, if supported and if it sees the light, as we hope, it will indeed strengthen what we currently have under the UNGPs, which is ensuring that corporations are directly accountable for their adverse impact.
Good. Sorry, thank you very much, Demilola. Appreciate that. I'll move on to Karen Spring's question. Thank you very much for this informative and wonderful discussion. Could the speakers comment on the political and social context in the EU that might help one, to understand why this change, this rollback or retreating dilution has occurred. Mr. Olawi mentioned political will and corporate influence, but can you expand on that, or are there other contributing factors?
So maybe I can take this. I mean, Marcus already made a very important point, which is that the European Parliament has changed quite a lot. And in fact, I do remember the sort of race it was in 2024 to adopt before the European election of June 2024. This was an absolute necessity to conclude that, because I think a lot of people, in a lot of observers, let's say, saw it coming that the parliament would change significantly. So that is definitely a reason. But we could also say that this, let's still call it a rollback against, generally speaking, sustainability legislation had started already before that. And by the way, it's not just on corporate sustainability. It's not just on the reporting directive, on the due diligence directive. It affects other areas. It affects the deforestation regulation, which is also introduces a sort of due diligence mechanism. And it affects also other instruments. The farm to fork strategy, for example, which was this really ambitious strategy around sustainable food systems, is also very much rolled back. So, I mean, it is part of a broader, let's say, attack on the sustainability agenda of the EU that was very ambitious. I think this point was made earlier, that the EU had since 2020, and the Green Deal, the EU Green Deal ambitions really had put itself and presented itself as a sustainability leader. And we saw very quickly after that things sort of switch for various reasons. I think one of them is, in general, the rise of sort of populist thought and populist parties that like to have very simple solutions that are not solutions, but to very complex problems. We saw also certainly the re-election of Trump didn't help either, because I think the reaction of a lot of, let's say, the business community was to refocus on the core of their business and to sort of resist to, at least from the EU perspective, to what was coming from the Trump administration. And that's not really conducive, I think, to focus on sustainability and human rights. It should be, but unfortunately, this is not how it was interpreted. And yeah, the Draghi report to me was also a very important development, and it was clear that it was taken very seriously by EU institutions. And if you put all of that together, then you have the result that we see. As Marcus said, if we hadn't adopted a stronger text 2 years before, we wouldn't be even talking about this. So I'd like to see it in that way. But unfortunately, it doesn't concern only the CSDDD or the legally binding instrument. It is sort of across the board.
Thank you. Marcus,
if I
did
could
you
just-
have... go ahead, Damalula. Yeah.
Yeah, I just wanted to add maybe an outsider's perspective as well on this, someone viewing EU developments from the outside. I think the Russia-Ukraine war also exposed the vulnerability of the EU's energy supply chain, which affected a number of things. I was in Doha when the Minister for Energy in Doha had said that if the EU continued with the CSDDD in the early draft, that the Qatar would rethink its supply of natural gas to the EU. Outsiders do believe that the aftermath, it may not be true, but the aftermath of that threat was some of the announcements. So which again shows that when you have challenges with the supply of your energy resources and you then depend on other parts of the world to meet those demands, then it could be possible that political will may be weakened if especially when energy security is concerned, which is often a crucial issue when it comes to votes, right? So I think the Russia-Ukraine war, led to EU depending on energy sources from different parts of the world, which may be a factor as well.
Thank you, Damilola. Marcus, do you have any thoughts on
Yeah,
this?
maybe just two last, or at least not last, but the very quick thoughts on this. Firstly, I agree, of course, with what Nadia said, that there have been other developments, but we should also be mindful of the fact that not everything has been rolled back. So the forced labor regulation still stands. I mean, obviously, knock on wood, we don't know. And then I think it's also important to realize that maybe we fell also victim to the stories and the narratives that the EU Commission, the old Commission, was telling us, that all of this was so great and about sustainability and human rights, that we failed to also see the problems of some of these regulations. So my interpretation of the delay of the implementation of the deforestation regulation, for example, is also that it wasn't really thought through and certainly was not discussed with the partners that would be affected by it. So from a certain point of view, you could also say, well, why is the EU rushing to all these regulations without actually consulting meaningfully with its partners? I mean, certainly this is a reading of the Indonesians when it comes to the deforestation regulation. So maybe we should also, those of us who are sort of concerned about these regulations, should also consider them in the broader perspective, that maybe the EU was also rushing a little bit too far. And again, I mean, I think it was telling that the EU was rushing unilaterally and was relatively reluctant also in Geneva. I think we should really be arguing for a global setting and a global forum in which these discussions take place.
Thank you very much, Marcus. I think this is a very good place to finish our conversation. So I want to pass it over to Una.
Thanks very much, Penelope, and merci beaucoup. On behalf of the Human Rights Research and Education Center, the International Law Association of Canada, and everyone on this webinar, Business and Human Rights Updates from Europe and Beyond, I'd like to thank our moderator, Penelope Simons, and the excellent speakers, Marcus Krajewski, Nadia Banaz, and Damilola Olawuyi, for providing us with so much useful information to take away today. So thank you also to the audience for your attention and your excellent questions, which have really pursued this discussion much further. So veuillez suivre le CRRDP et l'ADI Canada sur nos sites web et médias sociaux respectifs pour nos prochains événements. I wish everyone a wonderful rest of the day. Je vous souhaite à tous un excellent reste de la journée. Merci beaucoup. Thank you.
Thanks so much, Una. Thank you very much,
Thank
everybody.
you.
This was
Au
a great
revoir.
discussion.
Merci beaucoup.
Appreciate it. Au revoir.
Merci.
Thanks.
Thank you.
Bye.
Bye.